Hi, Ted Carr here with Berkeley Law and Technology Group. I'm one of the partners of the firm, and today I'm going to be talking about trademark, um, receiving a trademark cease and desist letter. So, if you've received a letter from a third party saying that you're infringing on their trademark, what do you do? Well, the first thing I would do is I would reach out to legal counsel. I think it's important that at that point in time, whether you've been handling your trademark matters yourself or you have an attorney, I would reach out to an attorney to get some assistance. Now, there's a number of different factors that go into how we respond to a trademark infringement assertion. The first thing we're going to look at if you come to us is let's figure out if the other party is a big company, a small company. What do they really want? Are they looking to potentially sue us? Or are they just wanting us to stop using the mark? Usually they just want us to stop using the mark. And so then the next thing we're going to look at is, do they truly have priority over us in the area where we are using the mark? Or do we have priority over them based on our common law usage? And sometimes that's easy to decipher. Other times it may not be so easy to decipher. It depends on the scope of use. It depends on whether or not they have a registered mark that they're relying upon, or if they're relying on common law rights. But there are a number of factors that I look at. Look at business databases. I can look at the World Wide Web, look at the trademark registration, U.S. and foreign. Try to get a sense for the scope of their use of the mark and how important it is to them. There are a number of things that you may also want to consider. There are potentially damages once you're put on notice that could be treble damages if you don't stop infringing after you've been put on notice. And so, or if you didn't perform a search and you just started using the mark, that also could make you liable for treble damages. So it's important that you take an assertion like that serious, and it's important that you get a good legal analysis performed by an attorney, a trademark attorney, that can evaluate your risks, your options, and then oftentimes we're going to be putting a letter together that will go back to the other side, explaining or responding to their assertion, and perhaps indicating that we're going to stop using the mark or push back if we don't think that we need to stop using the mark. There's a number of different factors that go into that response letter and how forceful we're going to be so that we don't